And now, it's the moment you've all been waiting for, the Drunken Tyromancy Show!
I did a video which was about Palestine. Having been given that suggestion, I was thinking the other day, what else needs us all to speak about it? And I thought of somebody else who certainly needs our help, and that's of course Julian Assange. Now, I don't know at the moment what's kind of going to be in the future for him, and I doubt many people do. I followed Richard Medhurst's coverage of the trial a little bit, but I don't know what the end outcome was. I just haven't caught up with that as yet. But there's not really anything of value that I can personally offer to that side of the conversation. So I thought to myself that I would write something which I can add to the conversation, which is about the law itself and which has an impact on interpreting what's going on from a legal perspective. So that's what I've written this article on. And what I'll do here is I will pretty much follow it. I'm not going to just read it to you, of course. What I want to do with you is to just harp on a few points, particularly to really drive home the importance of these points. And that begins with talking about within the law, there are many, many things which are not as they seem on the surface. Some of this is direct and intentional misuse and creation of deceptive language to fool people. Some of it is simply misinterpretation of what the law actually is. And unfortunately, there's a lot of that even within the legal profession, where lawyers and barristers and judges and whoever else who are otherwise actually experts in law, but because they have themselves been suckered by this in much the same way as many medical professionals were suckered by the scamdemic and the fraud behind that. And as I pointed out in that article and that video, a lot of that came back to the subtle misuse and deceptiveness of language. Because if you can put into the mix something subtle enough that people won't see it, like their brain just skips past it. That's all it takes to fool somebody, because once you've got that thing in the back door, then you start extrapolating all of the conclusions that one would draw if that prior statement was true, and nobody's questioning the prior statement because they just accepted it because they didn't see that subtle misuse of language. So that's what I want to add into this, is to go back to the foundations of law, both in terms of language and in terms of what the law is and what that tells us about what must be. It doesn't matter if what I am about to tell you is written in any legal textbook anywhere in the world. That is irrelevant. And the reason why it's irrelevant is because the law as a system exists within the universe, and it must obey the laws of the universe. Now, within the law, this is actually recognized to some degree in the principle of natural law. Now, many people misinterpret this as meaning the laws of God because they are themselves religious. What natural law really is, though, is it's about the laws of logic and the laws of physics and the laws of maths, because these things are natural laws. They're not human inventions. Our language to describe them is a human invention, but the thing described is a natural principle. So logic is a natural principle of the universe. Mathematics is a natural language of the universe. Certain aspects of sciences, and particularly if you look at it as all sciences essentially come out of logic, maths, and physics. The reason why I begin with this particular conversation is because the law exists within this universe, this reality, whatever you want to call it. And it must abide by the principles that govern this universe. One of the reasons for this is because the law is a system. And that's not just a word that human beings invented to use for our purposes. It is a view of certain combined elements and their relationships together and the boundary condition that defines the boundary of the system you're looking at. It is, in this regard, an emergent object, right? It only emerges out of our decision to view things as collected in this way, of their relationships, the elements, and what goes in and what comes out, and how things are stored and changed and so forth within this system boundary. But nonetheless, we are looking at real things, we are measuring real things, and we are collecting them into a valid viewpoint. It might not be the only viewpoint, but no other viewpoint is going to invalidate the analysis we get out of this. It's just going to confirm it from a different perspective if it too is also valid as another viewpoint. When we look at the law as a system, it is meaningful to say that it is a system, and something that we know about systems. There are two things that all systems must do. It doesn't matter whether you're talking about a mechanical system, an electrical or electronic system, a computer system, a number system. All systems obey these two principles. One, they must be self-congruent. And two, they must abide by the laws governing the domain in which they reside. For any system to be fully functional and without dysfunction, those two things must be adhered to. You don't get a choice, and it doesn't matter what's written in some textbook, it doesn't matter what legislation they write, nothing else has any impact over this. This, and even to use legal language in saying it, this takes precedence in law. This is natural law itself. It is a natural law that all systems must be self-congruent and abide by the laws governing the domain in which they reside. And I'll give you an example of what this means using a mechanical system, just so that you understand the concept. If you have a machine which has been defined in terms of how it was designed for its functionality to be expressed, it is that this machine, say, has these levers, and you can move the positions of these levers in order to express different functionality. So different positions of the lever are going to affect some kind of variable which impacts the machine's functional expression. Now, because this machine exists within the laws, within the domain of mechanics and physics, it must abide by the laws of mechanics and physics. And it must be self-congruent. So here's the thing. Imagine you have the two levers and they can only go in this direction, forward or backward, parallel to each other, okay? Then if the varying combinations of positions of these two levers are going to change the functional expression of the machine, that's fine, because they are congruent and obeying the laws of physics. But if there are functions expressed at various positions of these two levers, like the combination of positions of the two levers, and the two levers were to be at an angle so that they can't move through each other. So they are locked, like this one is locked, that it can only ever be above that one, right? So now what you have is a system that is not congruent with itself, because we can never express the functionality that was described by this one being above that one, because it can never get through it, right? Now, sure, you could fix that by modifying the machine somehow to allow it to sort of pull out and go around or whatever, but it would have been better in the first place to just make them parallel if that was possible. If not possible, you'd find some other solution. But the point being, the reason why the machine is dysfunctional, unable to fully express its total functionality as it was designed, is because there is a flaw. It is not congruent with itself, and it's not congruent with the laws of physics. It's expecting these two levers to be able to pass through each other to be able to attain certain combinations of positions which express functionality. That functionality is now not able to be expressed because of the design flaw. Therefore, the machine is not fully functional, and it is not without dysfunction. Once you understand that principle, you can now apply this to any system. It doesn't matter what type. It is always true, and I hope that my description has convinced you of that. But if not, then seriously, just go out and think about it. Go find, some system that does not obey these rules, because I will guarantee you there's only one exception. And if you think you found another one, then you are mistaken, right? And, if you were to describe it to me, I'm sure I could easily spot your mistake. But here's the one kind of partial exception, which is a nonsensical or fantasy system. So in your imagination, in a storyline, you can do whatever you want. You could have a system which was completely nonsensical, completely fantastical, and it would still, technically speaking, be a system, but it exists within a subdomain of fantasy. And that subdomain of fantasy certainly does, to some degree, have to abide by the rules of the superdomain that it itself is an element of. But within this subdomain, it has an exception to certain other rules. Why? Because it is fantasy. So the reason why this is only a partial exception is because it actually is congruent with itself. It is obeying the laws of the domain in which it resides, because any laws of any superdomain in which that domain resides, it has an exception to them, because the very definition of what it is a fantasy world. Right? It can do anything you want it to do. It's not meant to be real in other ways that other things are real. It's real in the sense that it's a real fantasy. It's a real storyline. It's a real whatever it is. It has no physicality in the way that other things have physicality. The point being here that if you want to look at the law, you cannot look at it from purely a perspective of what is taught about law. And part of the reason for that, I'm pretty sure, would go something like this. Now, I'm not saying that this is definitively the reason, but this certainly would make sense and it would certainly explain it. In history, dating back hundreds of years, possibly a few thousand years, I mean, I don't know how far this goes back. All I know is that contract law, to the best of certain people's knowledge when I read up on about it, apparently it goes back to Roman times. Now, maybe there are other cultures from which the same principles go back further, but what we know is that contract law is that old. It's one of the oldest areas of law, contract law. Given that part of the whole purpose of a system of law was to resolve disputes. In fact, it's probably the main purpose. It's probably the only really core reason for which the entire thing came about. Because if you are a ruler of a kingdom and you don't give a shit what anybody says or thinks, and you're just going to rule by domination, then you don't have a system of law. You just basically, your will is law, and you just do whatever you want, and your whims and ideas can change from day to day, and everybody else is just, well, bad luck. I changed my mind today and you're doing the wrong thing, so I'm going to kill you. You know, prior to any culture realizing that maybe that's not such a great system. And at some point, we know that at least the Romans came up with this whole concept of contract law. Now, think about that. They came up with contract law. Now, why would that be? Well, it's because that even if your civilization has slaves and peasants and a kind of lower class who have no rights, nonetheless, in order to dominate them, you had to have a ruling class. And that ruling class is not necessarily all of one mind. They may very well be all of one mind that the slaves have to say slaves, perhaps, but they're all fighting and vying for power and trying to fuck each other over in the meantime, because what can you get by fucking over a peasant? What can you get by enslaving a peasant? Not much. You can get their labor, that's it. But these other guys over here, they've got a lot of stuff. And they might be looking at you to say, well, I'm going to rob those people. So all these rich people effectively, robbing each other. Now, that might have been because they were from different cities, different populations, even within the same kingdom, whatever. And if you have a single ruler of the whole kingdom, but he has his nobles and lords helping him to keep the rest of the population basically, sort of subservient, then he needs them to get along. So what is a perfectly natural thing for them to do? They all come to the king, right, to have their disputes resolved, because he wants to also kind of, manipulate the situation so that nobody gains too much power and he stays at the top, right? This is how these systems would have evolved with these things in mind. Even if it's not documented, it's pretty obvious that this is the kind of thing that would have gone on. He's also faced with the dilemma that he has to at least make his judgment appear to be impartial. Now, at some point in this process, it would have been basically the king also saying, I'm too busy for all this nonsense, and basically delegating the decision-making to trusted advisors and then setting up courts and so forth so that in what was initially the king's court became the court of law. Along with this came the invention of legalese, the language that the legal scholars used to effectively keep everyone out of understanding how and why they came to the decisions they did. And when I studied law years ago, my legal professor, who remains actually today, she's still a practicing lawyer, but she wrote our textbook, and she went into like a lot of detail telling us about they constructed a language based upon Latin, French, Greek, and I think a few other things all kind of mixed together so that nobody else would know what they were talking about. Now, the advantage here is, of course, that if you have two people coming at each other and you have the legal people, they now have a language which neither party can understand, and so they can interpret law in a way that neither party's understanding. They're only going to understand the end decision. And so long as it is according to some kind of like, if you want plausible deniability that they were following the principles, do you see what I mean? Like they're able to exclude other people from their profession. They're able to exclude other people from their discussions. They're able to implement a law that on the surface of things might seem like it's applying the law equally to both parties, but in reality they could be biasing people that the king said, I want these people to win. Now, many things like this probably went on, but there's, of course, at the same time, a limit to what you can actually do in this way because people still aren't necessarily stupid. They would certainly see, hang on a minute here, this makes no sense. So what I suspect happened within this kind of evolution journey of the law was that the principles of logic had to be included in the legal arguments in order to come to the conclusions. So long as they're satisfied, then everything's good. But in order for them to be satisfied, the majority of cases had to follow logic. And even if the king has some bias in the equation, he's still going to also recognize at the same time, or at least his advisors would recognize, because, the kingdom itself, people's lives are on the line and they don't want to lose power. So it's more critical that they follow the truth. You are forced to make the true decision by logic in order to resolve a debate fairly, keep the parties both happy, to reduce internal conflict in your kingdom. You really don't have a choice in the matter, because the very reason it's come here is because it probably wasn't resolvable on the battlefield. Now, hopefully that case is going to prevent it from then being resolved on the battlefield as well, because you don't want that either. Why? Because there are other kingdoms that could invade, and you need to be at peace internally to be ready for those externally triggered conflicts that you have no power over except through foreign diplomacy, and hence, the links through to there. That's kind of like the logical pathway that we can look at as to why logic as a natural law found its way into legal arguments. Legal arguments have to be based on something, and in order to be convincing, in order to keep the parties satisfied and get the outcomes you need, they must be based on logic and reasoning. Contract law dates back as one of the earliest areas of law. It's about essentially resolving disputes, because what do? And now, mind you, as well, it indicates that there was already a dispute resolution process preceding the invention of contract law, because all it is basically about you saying that all these disputes which we had previously been resolving as well within our kingdom, we want to reduce our workload of resolving disputes. How can we do that? Well, we can do that by formalizing this notion of an agreement, formalizing this notion of a contract. So we can then spread this concept throughout our society that people will not just make verbal agreements, but we will define what constitutes a valid contract or valid legally enforceable agreement. They may not have come up with that concept of legally enforceable right from the start, but the point is, you can imagine that would have been the natural evolution of the process. As we begin with people just making verbal deals with each other, many of them probably couldn't even write anyway, and then as time goes by, because those disputes are always resolved by the parties coming to their local lord or noble, and their court, and then to the later set up courts of law specifically, this means that in order to develop contract law very early in the piece, then we must have had the development of contracts themselves, right? The idea of formalizing what an agreement is, what a contract is, what a treaty is, all these different things. With all that in mind, the other part of natural law that I want to mention here is the idea of the laws of physics, because in your legal argument, at some point they realized that they had to draw on evidence. Now, if you've ever watched Monty Python, of course, you'll know about the famous thing of she's a witch, and it's a joke on these kind of early forms of law, is that, they might not have understood the idea of physical evidence, forensic evidence, chemical evidence, evidence of mathematical equations. But as society grew and evolved and threw away superstitions and got more understanding of logic and mathematics and philosophies and sciences and so forth, because remember, there were other cultures elsewhere that they're doing trade with, and so they are learning from these other cultures. What they're learning is going into this conflict resolution process. So wherever these earliest understandings of physics, prior probably to the invention of the word physics to describe them, and probably also very flawed understandings, very inaccurate understandings, nonetheless, they would have certain understandings which were not too far off the truth. They could be used within a legal argument as proof. Prior to this, when there would have been, she's a witch, look, she's got a long nose, she's wearing a pointy hat, she's got a wart, she turned me into a newt, but I got better. All of these kind of things are going to slowly start diluting out of the equation, and what's coming in to replace them is going to be real evidence. And that real evidence over time gets recognized as relying on the natural laws of physics. And at some point within all of this evolution of these systems, what you have is the recognition that some of these things are natural laws. All of our man-made law rests upon them, and they must take precedence in law, because we need to be able to rely on whose argument is actually correct, whose evidence is actually valid, whose conclusions is supported by both the argument and the evidence to the degree that we can't have gotten things wrong beyond reasonable doubt. All of these things come out over time as a natural part of this evolution. No matter what textbook says otherwise, it cannot be denied that natural law is not something you can choose to use or not. You don't have a valid legal argument without it. You don't have valid evidence without it. Therefore, they take precedence above all other law. And that's what I want to look into here, because what my article is doing is trying to show how, from a perspective of law, everything that has been done to Julian Assange and countless other people is absolute, total fraud from start to finish under law. Under how the law should be interpreted and how it should work. Not how it is interpreted or how it does work, but how it should be. Because these things are true and undeniable. You can get me the greatest legal scholar in the world, and they will be wrong if they contradict what I just said about natural law, right? It doesn't matter the truth precisely of the origin. It doesn't matter whether there is or isn't a God. What matters is that you do not have a valid legal argument without philosophical logic. You do not have a valid set of evidence for that argument unless you're abiding by logic, maths, physics, and any other kind of relevant sciences and so forth, which come out of physics to show, chemistry, geology, all these things. And you have to understand the difference between an hypothesis where you have an idea that is as yet unproven, a thesis in which you explain your hypothesis and attempt to prove it. So this is your argument and your evidence and your process for trying to prove that the hypothesis is true. What we have here is the merging of science and law. Now, so long as you abide by the things that I'm saying, then what you get is a completely different interpretation of what the law is all about, as opposed to the utter BS that we kept getting told. Now, where it comes into precedence, I've specifically mentioned here precedence again, and I will just talk about this here because this concept of precedence is critical to a correct interpretation of law. The notion is both the things that I've already said about the fact that you don't have a valid legal argument or valid evidence without precedence of natural law, but this also explains why natural law is so fundamental and why contract law is so old and why it's so connected to natural law in this way is they are connected through precedence. When we define, so just to be clear here as well, precedence is divided into two areas: legal precedence and precedence of law, which are two different things. So precedence of law is which law comes first, and that's the bit that I want to talk to you about the link between contract law and natural law and how they create the concept of precedence itself. So that's precedence of law. Which law comes first? Which law is more fundamental? Which law other higher order laws are subservient to, right? So these laws are anything which takes precedence in law is the foundation. Other things rest upon it. If you remove the foundation, they fall, right? They need this. It doesn't need them, they need this. So that's what the precedence of law is, whereas legal precedence, and this comes into the true meaning of the differences in meaning between legal and lawful. They are not synonyms. I'll go into this in a minute, but legal precedence is about the precedence of legal decisions. So this has more to do with the courts of law and their decision-making process, that when a judge of a court is making a decision, he will abide by the decisions made by typically abide by the decisions made by equal, but definitely obey the decisions made by higher courts, because his court is subservient to any higher court. It is considered equal with other sibling courts at the same level, at the same hierarchy within the system. And so, for example, the states all have their supreme courts, which are at the same level. Now, they will typically abide by each other's decisions on certain things, but not necessarily. They can disagree. It's just considered bad form to disagree, unless you have really good cause. But where it's a higher court, they are governed by that decision. They have to make decisions which abide by the similar decisions of a higher court in the same area of law. So that's the legal precedence thing. So it governs the interpretation of law, the application of law, not what the law is. Where this comes out of specifically is in the definition of a contract. So this is where we get the connection here, okay? So a contract, in some definitions, there are only 5 criteria. In others, there are 6, and I've even seen one in which there was 7. But I typically go with the one that is 6, and those 6 criteria are as follows. For there to be a valid contract, a valid and legally enforceable contract, there must be an offer made, acceptance of the offer, consideration or payment for whatever goods or services the offer was relating to, lawfulness of the terms of the contract. And this is key to precedence: lawfulness of the terms of the contract. The contract itself must be lawful, must abide by precedence. So it must be lawful. There must be an intention to form legal relations, right? So you can't deceive somebody into a contract. That would invalidate the contract. The person must intend to enter into this legally binding relationship. And because the terms must also be lawful, there is a famous saying in law which goes, you cannot by way of contract remove someone's rights at law. And this is what actually invalidates a lot of legislation, which I'll go into later, because essentially if you have a right at law, then you can't write valid legislation which contravenes that, because the rights took precedence in law. right? There is no valid legislation of any kind which can validly contradict this. All of that legislation written is bullshit. It's not valid. It corrupts the legal system. It causes dysfunction. So you cannot accept those rulings. So there must be the intention to form legal relations. There must be lawfulness of the terms of the contract. You cannot, by way of contract, remove someone's rights at law. Ability in law to form legal relations. So it's like, for example, if a person is a minor, like they are sort of under the age of consent, they don't necessarily understand what it is that they are signing. So this is, in a sense, on this particular case, but this is not the only case of ability to form legal relations. This is just one specific one, which just happens to coincide with that intention to form legal relations. So the idea here is that if somebody is, young and ignorant and naive, somebody else would be able to trick them into a contract. And so the idea of this thing to do with age is to acknowledge that young people should be protected from predatory practices of deceiving them into a contract. But it's already covered under the idea of intentions. There are various other ways as well in which a person could not have the ability to form legal relations. So, for example, they may be bound by an existing contract. So hence, if that contract contradicts the terms of the new contract, then effectively, again, precedence in law, right, is that that legal precedent of that existing contract is going to prevent you from entering a contrary contract. Now, if you did anyway, you would be completely at fault to both other parties to those two contracts, and therefore they could both come after you. Once you understand that this is how we define what is a valid contract, and you can see the reasoning through which they came to this, because if you look at that as a set of rules that govern what is a valid contract, it makes perfect sense in a logical argument. And what it means is that no matter your position on any subject, you could adjudicate disputes under law around these legal contracts. So it's really quite a clever way of defining things if you think about it in the context of all of the other fields of law. But it also explains the whole concept of precedence, of where it comes from logically, because specifically the fourth criterion here, that the contract itself, the terms of the contract must be lawful. So they must abide by that which preceded them. And if you now think of all law, all man-made law that is, as being some form of social or corporate contract, on that basis, you can easily see why this concept of precedence comes up and is so central. Because if all of the other laws are some form of contract or agreement or treaty, then they must abide by these things to be valid too, which explains the precedence amongst them. And so what you've actually created is a system whereby it's founded on natural law, logic, maths, physics, and so forth. That gives rise to contract law, agreements, and now we can then specialize that into the two main fields of civil law and criminal law. And I'll go into this in a minute as well, because this is specifically relevant to Julian's case, where we start looking at the difference between civil and criminal. Because if everything's a contract, accepting natural law, but contract law has a contract to natural law, if you will, like a man-made contract with the universe itself, meaning that we acknowledge that the laws of the universe are not something that we can change. They just are what they are. They don't care what we think about them. They just are, right? And it's our job to understand them and to employ it within our things, because if we don't, then they're going to be illogical. They won't work. They will be dysfunctional. And so in this way, again, doesn't matter what people say to the contrary. Doesn't matter if they're the world's greatest legal scholar. None of that stuff matters. Doesn't matter what legislation is written, what's in your constitution. It's all irrelevant. What matters is the fact that these principles are inescapable. Having explained contract law and precedence and their relationship, The next thing that I want to clarify here is, actually there's two things. I mentioned one already, which is this difference between legal and lawful, and I'll go into that in a minute, but I'll just, I also think I mentioned this one here too, law versus legislation. Many people mistakenly think that legislation is law. This is not true. Legislation is social and corporate contract. It operates under the law. It must abide by the law. There are fields of law affecting it and which determine how it works. But what legislation is itself is not law, even if it is legally enforceable to certain people. And herein lies the way that another deception, the wool is pulled over our eyes when people start telling you that legislation is law. No, it's not. It's contract. It is subservient to the law and it cannot overwrite the law, not validly. I know they've tried to do it. I know they've successfully gotten away with it, but that's not the point. The point is how things should be, how logic and reasoning tell us they have to be in order to be without corruption, without dysfunction, and to be fully functional, and that is a requirement for achieving justice. You cannot get justice if you're corrupting the system, right? If it's dysfunctional. Law versus legislation. So the law is, as I've described, it's essentially a system of legal arguments, of natural law, of logic, and the evidence which helps us identify how we can differentiate fact from fiction. Because the whole purpose, and indeed the only purpose of a court case, should be to determine the truth. I really hope that people will always be skeptical of any accusation made against anyone where the behavior of that person seems completely incongruent with the accusations being made against them. Now, take, for example, Julian Assange. I remember when they made those accusations against him about sexual misconduct. There was a video that I saw where he was actually dancing in a nightclub and having some fun. And I thought, man, this guy's got some moves, He was actually looking pretty cool on the dance floor. And I thought, what a brilliant thing to be such an intelligent guy, such a skillful guy, in terms of his abilities, such an ethical man, such a courageous man. What the hell would he need to molest women for? They'd be fucking going for him. Maybe not all of them. I know there's a lot of shallow women out there, but there's a hell of a lot of women who would actually love to be with somebody like Julian, as his wife proves, right? She's a beautiful woman. She's a dedicated woman. She's an intelligent woman, and she's stuck by his side. So how could you possibly claim that this is a man who needs to... No, he doesn't. He may not be built of muscle and everything else, but he's a brilliant, ethical man. And if you don't understand how sexy the mind is to a lot of people, then you're an idiot. It was not remotely surprising that these people recanted their testimony. Right, it was not remotely surprising to hear that they'd been bribed or blackmailed or whatever the case might be, because the charges were ludicrous. Why does a man who's so intelligent, who can dance like that, why does he need to molest women? No, he doesn't. Now, I'm not saying that dating is easy for... shit, a lot of people told me for many, many years of my life that he's such a handsome guy, you're tall and everything, women must be all over you. And I was like, actually, no. But, I get that. I get it that it's not necessarily easy just because you're smart. In fact, sometimes that, from my perspective, can actually make it harder, because you're out there in the world and you're meeting all these people and you can see women who are good looking. But, how many times, I can't tell you, that I've seen a woman who is good looking, but then she does something or says something and I think, oh God, you're an idiot. My interest in her just plummets. In talking about law versus legislation, you cannot think of legislation as law. You have to think of it as contract or agreement operating under the law, operating within the law, and valid or invalid according to the law, just like any other contract or agreement. You don't get a choice in this. That's just how it is. Any law, by this definition, remembering that as well, we've already stated that you cannot by way of contract remove someone's rights at law. Any law written, created specifically to persecute Julian Assange is by definition invalid. It's bullshit. And if the courts are listening to that, that proves conclusively they are corrupt. And I will say that to their face. If any of them ever happens to watch this video, if you do that, you are corrupt or an idiot, an imbecile. If you do not understand your own fucking specialization that you've spent your entire life doing, and some guy who never completed a law degree, right? I didn't. I wasn't even enrolled in law. I just did some law subjects as electives. If I can tell you this stuff and you never, then you're an idiot. You're incompetent. How the fuck am I able to educate you? Why? Because you are just like all of the others who went to university from a good school. You accepted what you were told. You got brainwashed into it. You never fucking questioned anything. If it was told to you by authority, you read the books. You're very, very competent on reading what's there, but you're clearly not very competent on thinking about it. And what's more, you are now faced with a position where there is clearly a case of criminality persecuting a good man, and you don't even have the brains or courage to support this guy, and instead you're favouring these fuckwits? What respect do you want from people? Because you are not going to get it from me with that fucking shitty attitude of yours and that fucking shitty perspective in which you cannot comprehend how badly you've misinterpreted your own field of specialisation. That is appalling on many levels. Unless, of course, you finally have the courage to actually stand by this guy. And in which case, fuck, I'll give you a hug, I'll buy you a beer, for God's sakes. Just do the right thing, look at how things should have been interpreted and stick to it. It doesn't matter what they threaten you with, fascism is worse. Fascism is that happening to everybody, and every single day, all you look around and see is misery and psychos. That's fascism. Don't fucking help it one single bit. What the communists got right, one of many things they got right, was killing the fascists. They got rid of them, as many as they possibly could. And the reason why fascism is the home of Western society is because we didn't. Our ancestors were cowards. The ones who weren't fascists themselves were cowards. They let it be, they let it live, they let it grow, they let it fester. And now they themselves are being influenced by it because they're gullible, they're brainwashed, and they're intellectually lazy and cowardly. Julian Assange, by contrast, is a brilliant man and a courageous man, and he deserves not only to be free, but to massively be compensated. You know, like, if ever there was a case for the world record in compensation, I mean, I know that there's other cases that probably deserve that title too, but God, he's got to be in there in the running at least. You know, to not put him in the running would be a crime in itself. And remember that the purpose of government is, again, we're talking about what it's supposed to be here. It is supposed to be not government of the people, right? They are not your lords and masters. They are not your, owners. They are not your bosses. They are, as public servants, your servant. This is another point we need to drive home, is that the whole purpose of government existing is to have a group of people who have been empowered in a limited way, limited by other law and specifically constitutional law on top of that, to write legislation which is supposed to be solely about their own operations. It's not supposed to be about what you're doing. You are supposed to be a free, sovereign person. As, what's his name? From the time traveler guy, he's a Scottish dude. Trying to think of his name, it'll come back to me, but probably some of you know who I'm talking about already, but he was talking about what Magna Carta was about. Magna Carta, following the peasant and minor lords uprising, okay, dating back, so this is going back a long time, I don't know exactly what the year was, but the point is it's about acknowledging that every member of the Commonwealth, every person was a sovereign individual, and the whole point of the king was simply just that he was chief amongst, or first amongst, sovereigns. That was the resolution of the conflict, was Magna Carta, acknowledging that. So in law, with this as one of the founding sort of documents of the documented side of law in terms of a social agreement, the conflict stopped because those at the bottom who gathered together had enough power and force to force this decision on the nobles, right, and the High King over the whole kingdom. The idea of government in more modern times is about getting our collective resources, pooling them together through taxation. Now, I know that this has been corrupted, okay? This is not a discussion on whether this has been corrupted and whether your money is being used by criminals. Of course that's happening. But what it is supposed to be about is us as a community getting together, electing some people to say, right, can you guys handle this for us all? Because we've got other stuff to do. I'm a doctor, he's a truck driver, this person's doing that. We don't have time for it. So that's the purpose of these elections, to get people in there who are going to collectively decide how to use collective resources for things that we all need: roads, schools, hospitals, and so forth. Now, of course, all this system of taxation came from earlier origins where it was really just about those in power taxing everybody so that they could sit back in luxury and rule. Sure, that's where it came from. But after Magna Carta, things changed. Right, because that was where the I think was it Longshanks or something? Maybe somebody who knows the history of this. There was a guy whose nickname was Longshanks, who was one of the kings of England. Who, if it's not him, some other guy who was, well, of course, but you know what I mean. He was a particularly brutal ruler. And so the reason for the uprising was because it was too much pressure, too much taxation, too much of his domination. And eventually the people just snapped and they came back and they won Magna Carta as an agreement. Now, of course, neither side wanted to keep fighting, but they brought it to that head where those, in society who retained the most power still acknowledged enough of this stuff through the agreement to make society more fair. And what did we then get? We got a massive explosion in all of the development within society. Because what had been holding it back up until that point in Western society was this idea that you were either a noble or you were a peasant. What does that mean? It means a loss of all of the brilliance that can come out of all of these people. Like the majority of the people are just kept impoverished. What happens when you change that situation? So maybe sure, they still have to work hard because they don't have this inherited wealth situation. They don't have the power, but they've been given enough power now to keep more of their earnings from their hard labor, which can make their life more comfortable, which can give them more time to think, to dream, to write, to paint, to whatever it is that their interest is. And what that did for society was that it brought out an explosion of ideas. The Industrial Revolution, the Renaissance. So the whole purpose of government, pooling resources for communal good to create the things we need to continue this beautiful growth and evolution of society, whereby we get amazing music, we get amazing artwork, we get amazing ideas and inventions and so forth. What our current ruling class has been doing, particularly since like about the 1970s, is destroying all of that. And it wasn't noticed at first because the momentum of all the good things carried on for quite some time. But if you look at the idea of real wages growth, that was when it just flatlined. Now, there are still people who benefit greatly, but the situation's been screwed up because all of that investment into people has effectively disappeared. On which subject of, just to drive home the true cost of what this is about, I'll mention again, as I mentioned in a previous video, this interview with a guy who designs, builds, operates and maintains supercomputers in a documentary that I saw being interviewed. And he's sitting on a stool in front of this bank of like computer hardware in this clean warehouse room. It was a gigantic room, gigantic computer banks. And what he basically said was this: I really don't know why people pay me to do this, because one human brain is the equivalent of 200 million of these machines linked in a network we have no idea how to do. So here's my advice: if you want a better supercomputer, find someone you love, have sex and make a baby. So when you think about human potential in that respect, and add on to that the things that I said to expand his words, where we say like, linked in a network we don't understand, running software we barely understand, armed with a a body which can sexually replicate and change and watch itself learning and thinking and change its own methods of learning and thinking and collaborate and communicate, and create tools and do stuff. So this insanely powerful supercomputer is armed with this equipment. It can artificially create additional equipment. It can change its own programming. If you understand that potential, then the only reason that we can attribute to this hardware up here seeming stupid for some people is because the programming is all wrong. If you have a supercomputer that you have polluted with bullshit, what's it going to do? It's going to pollute, it's going to produce bullshit results. And that's what most people are suffering when you see them as stupid, is that they are just a corrupted computer. Keeping people impoverished, giving people injustice instead of justice, all it does, the only thing it achieves, is to diminish society. That is the only outcome. And we just happen to live in a society with people at the top who are stupid enough that they cannot see this obvious argument. They cannot understand this obvious argument. They've never thought of this obvious argument. And instead, all they see is their own selfish short-term interests of, this guy's revealed our crimes, we have to attack him. They never think of hang on, he's right, we should stop being dicks. The most obvious solution, stop being a dick. That solves the problems far better than persecuting the guy who pointed out that you are being a dick. What don't you get about that? It's the kind of stuff that a primary school child can understand. A retarded primary school child could understand it. A stick, a dead leaf could understand it. And if you are so witless that you can't, rid the world of your stupidity once and for all. If you're such a coward that you won't change your behavior, well then what is there to respect about you? I can't. There's nothing respectable in it. And the next thing to cover is legal versus lawful. So again, here we have an issue with language where these two words are used as synonyms. And in the same way that legislation is not law, legal doesn't mean lawful. So the difference in these terms can be most simply described as lawful means something which abides by the law, so it is lawful. Legal means of or pertaining to the law. These terms being used interchangeably is an incorrect use of the language, and it's also very deceptive. So that what can happen is that somebody can say, that's illegal. And technically speaking, they might actually be right. Because what they're effectively saying, which they're not telling you, if we were to complete the sentence and put all the detail in, assuming they actually understand the full scope of the deception they're actually engaged in, it would go like this. They were saying, according to this unnamed, unmentioned contract, agreement or treaty, which I'm not even going into whether or not it's actually valid, your behavior is illegal. It is going against the terms of this contract or agreement, which I'm not even discussing whether it's valid or whether you're even a valid party to the agreement. I am just asserting without mentioning it that you are a valid party to the agreement, and I'm calling this the law by way of inference, even though it's not the law, it's an agreement, and I'm saying that you are in breach and implying that your behavior is unlawful, but actually only saying that it's illegal so that I have plausible deniability later if you happen to bring that up, and then I can say, well, actually I never said that it was unlawful, I said that it was illegal. That's the deception, if you get what I'm saying here, is that a contract is a legal instrument, but if a contract is invalid, it's because it's an unlawful legal instrument. Saying that it's legal doesn't mean that it's lawful. It just means that it is of or pertaining to the law. So saying that something is illegal is a deception to suggest that it means that it's unlawful. So a contract or behavior according to a contract that is illegal might still be lawful. Perfectly lawful behavior. Might go against this contract, making it illegal with respect to the contract, but that doesn't make it unlawful. Even if it's in breach of contract, even if the contract is valid, It can still be perfectly lawful behaviour, but now there is also a valid civil legal complaint against you for breaching the terms of the contract. You haven't broken the law, you've broken the contract. And there is contract law to define why, as we've already stated, why it's enforceable. Potentially part of the deception against Assange again, because effectively they would have plausible deniability by saying that what he did was, illegal, when in fact it was perfectly legal, in the sense that any contracts that he is a valid party to, he hasn't breached any of them. And I'd say that that's the case. So his behaviour is both legal and lawful, because they haven't actually shown any valid agreement that he is validly a party to that agreement and which he must abide by. So he's in breach of nothing. And they've tried to then, sort of say that, well, he's actually guilty of criminal behaviour. And so this distinction between civil and criminal is where there might not be any written or otherwise recorded contractual civil, agreement to be breached. And instead we can go into criminal law and say, well, he's guilty of a crime. But therein lies the difficulty, because, of course, you have to define what a crime is. And I'll go into explaining, and I do in the article, how criminal law relates to civil law and contract law, and why that field of law therefore becomes perfectly valid according to natural law and precedents and so forth. Were his actions unlawful? Clearly no. It's like, were they criminal? Well, in order for them to be criminal, you have to show that somebody came to harm, and they haven't done that. And even then, you'd still have to show a few other things as well to define it as a crime. So it really is just like a civil complaint, and it's an invalid one because he's not a party to it, and there's certainly nothing criminal about it whatsoever. They just want to pretend that there is by insinuating that somebody could have come to harm. But they can't show anybody who was harmed, and they can't show a valid argument or evidence as to the probability of anybody coming to harm, much less any kind of certainty. Because we want to base everything on contract law on top of natural law, and use that connection of precedents to explain how all other law can come about, we come out of natural law into contract law and then divide into civil and criminal. The reason for this being that in civil law, what we are dealing with is the breach of agreements. It doesn't necessarily mean that any law was broken, but we want to use the law to enforce the agreement so that society can function. You had an agreement, the agreement was valid, you breached the agreement, it's a civil complaint, and we will resolve it, and it might involve, payment of damages and so forth, financially, blah, 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 but it's not necessarily a crime per se in the kind of more extreme interpretations of criminal behaviour. Maybe there might be financial loss and financial harm, which you could argue constitutes calling it a crime, but we tend not to because of just the implications of that word, and we're not trying to criminalise the person per se, because that may very well have happened, even if through negligence or recklessness or whatever, still fairly innocently, and part of the purpose of the law and the courts is supposed to be justice, and it's not justice if you're going to basically destroy a human being over a civil complaint which can be resolved effectively and everything's fine. Where criminal law comes into it, we can argue that there are certain behaviours which go against an unwritten and unsigned social contract. So how can we therefore define it as a valid social contract? A crime is where there is some party that has been hurt. There must be damages, harm done. And there's a whole area of law talking about that, which is called tort law, I think. I think the word tort comes out of Latin. In criminal law, we are often also looking at tort law, but tort law could also apply to non-criminal harm. But in the criminal, what we're looking at is the fact that a crime was committed, which means we look at the fact that someone has been harmed. There has to be a party who was harmed. Secondly, there must have been either intention to do harm or reckless endangerment causing the harm, or negligence or breach of a legally enforceable duty of care resulting in the harm. Now, there may be a few other things as well. They're the only three that I'm aware of, but basically what it's saying is that it's not just a matter of whether your behaviour harmed somebody, but it also has to be shown to be harm caused by criminal conduct. So either you intended to hurt them, or you were reckless and you hurt them, or you were in breach of a duty of care, you were negligent and that resulted in hurting them. So we would define these things as sort of various levels of criminality because of the motivations or failures which resulted in the harm done. And otherwise, any harm done would purely come under tort law or as being a civil matter if it's not criminal. By which definition of a crime, we also come to recognise that breaking the law, where a person is talking about being in breach of legislation particularly, but also applying to any other contract, breaking the law is not a crime, right? Unless by breaking the law you cause harm to come to somebody else and intended to do harm, or it was reckless endangerment resulting in the harm, or it was negligence of breach of care, blah, blah, blah. And which is why, under international law, to bring back in the case of Palestine, they have the legal right under international law to use deadly force in defending themselves and in ousting an occupying force, the Israelis. And I remember when none of our maps ever showed Israel, and this is like from, the 1970s, the 1980s and so forth. And if you look dating back, you won't see any mention of Israel unless it's a map created by the Israelis. They are the only maps I've ever seen that ever mention any kind of ancient Israel, that don't exist otherwise. The point that I wanted to really make here was just that breaking the law is not necessarily a crime. And in the case that in breaking the law you do harm and even have the intention to do harm, there is still that exception under international law, because if somebody else is an invading force, like the Israelis, to Palestine, then the Palestinians have the right under international law to defend themselves, to push out the occupier. The other justification for invading is to say we need a Jewish state. Well, there were Jews already living very peacefully alongside all other Palestinians. They were Palestinians. There were Jew Palestinians living alongside Muslim Palestinians, living alongside Christian Palestinians. Palestine was a peaceful, secular nation. The only difficulty they really had to deal with was the aftermath of the breakup of the Ottoman Empire and the rule by the British. And in the same way as well, Julian has a right to defend himself. And I would argue that given the level of his persecution, if I saw a paramilitary team going into Belmarsh and killing every single last guard and person, whatever it took to get him out of there, I wouldn't shed a tear, not a single one. Because the fact is, all of those people, just like with the Nuremberg trials, where it was determined that just following orders is not a valid legal defense, right? In the same way, you are complicit in imprisoning an innocent man, a hero, for the benefit of criminals. You are complicit in the crime. You are persecuting him. You are torturing him. You are unlawfully detaining him. For something to be an enforceable civil matter, the contract must be valid. You must be a valid party to the contract. The other party must conclusively prove that you breached the terms of the contract and that the contract wasn't already invalidated by the time that happened, because if something else happened previously to invalidate and terminate the contract, then you are no longer bound by it. So they would have to prove that the contract's valid, that you're a valid party, that it wasn't already terminated by some prior breach, and that there was no kind of like other context, valid legal defense for such a breach. So even where you can show that a party did breach valid legislation, which they were ultimately bound to uphold, in that particular case, that still doesn't necessarily make that act a crime. It is not a crime per se to break the law, and legislation isn't law anyway. With respect to Julian, they can write any legislation they want. That doesn't make him a criminal, and it doesn't mean that he broke the law. What matters is whether the legal argument makes sense and is congruent with the entire system of law. And the legal system and the system of law are, again, not synonyms. The legal system is how it operates. It is effectively the corruption and fraud that goes on. The system of law is how it's supposed to operate, right? Now, the legal system as it stands references an existing understanding or interpretation of the system of law, but I'm telling you that that interpretation, that understanding is incomplete in certain areas, it is invalid in certain areas, and it is corrupt and fraudulent in certain areas. Here's where I want to get into the law of hypocrisy, which comes out of natural law and logic and becomes this basis for criminal law. And so I've already kind of mentioned this, but just to reiterate it here, that what we are talking about is the fact that in the social context of social contracts, whether they are written down or not, the social contract is that we are not going to run around killing each other without just cause. We are not going to run around engaging in other criminal behavior without just cause. You have to have a just cause in order to do something which might otherwise be considered criminal. And hence, we need to be certain what we mean by a just cause, because is it a just cause in one person's set of values but not another set of values, and in which case then, and this is why people misinterpret democracy and law as being might is right, or what do they call it, the majority rules. That's not what it's supposed to be about either. This is again a perversion of democracy. The word democracy actually from the ancient Greek means the exercising of power by people. But if your only option is to vote for somebody else to exercise power on your behalf, and they don't even do that, then what you have done is to abdicate power, not exercise it. So representative democracy, especially in the case where it's your only option and many of the people in the political system are corrupt, isn't any form of democracy at all. And certainly we cannot define this link between law and democracy as being an issue of majority rule. That's not what it's about. What it's about is legal arguments, and the reason why somebody might have a just cause to do something which would otherwise be considered criminal is because of what I call the law of hypocrisy. So the law of hypocrisy is basically saying that if the shoe were on the other foot and somebody did to you what you did to them without just cause as well, if somebody did to you what you did to them, you would not only argue against the very position that you yourself took moments before, but if they used the same logic and reasoning to justify it against you as you used when you justified against them, you'd be arguing against your own logic for how you rationalized that behavior. So that's hypocrisy. That's what it is. And clearly it doesn't have a valid logical basis. So therefore, if we want to define what constitutes criminal conduct, and we want to use this as a legal argument for justifying why you don't have to sign the contract, you don't have to verbally agree to the contract, you agree to the contract whether you agree or not. How do we do that? We do it through the law of hypocrisy, because it would be hypocritical not to. What is obviously true is that we have to really look at these specific circumstances for each individual. Now, what did Julian Assange do? Well, he exposed criminal behavior. The reality is that what you are doing, which is criminal, if somebody else did it to you, then you would argue against them. You would use the court system and you would be arguing this case against your own position, against your own behavior when somebody else is doing it to you. So you don't get to mention what somebody else does in exposing that. They are exposing your hypocrisy. The rule no longer applies for you to so bizarrely apply it to them exposing your criminality. It's not a valid argument. That's you using it as an excuse by twisting everything, right? You instigated criminal behavior. It is criminal. You are, by definition, you are placing yourselves there in the position of supposedly public servants, and you are not serving the public. And because you are so brainless, you cannot comprehend the idea of investing in infrastructure and people and skills and all this kind of stuff. And instead, your only thought is to go and rob other countries. That's because you're dumb as fuck. That's because you have no imagination. That's because you are scientifically illiterate and technically illiterate in every possible way that a person can fail to understand anything of significance. That is why you people are useless leaders. Useless. I don't care if you personally went to Jeffrey Epstein's island. If you are okay with bombing children, I don't care if you rape them or murder them, that's the same thing. You are still engaged in child abuse. You are no better than a child rapist. And what you are doing to Julian is, again, it's nothing but criminal, and you don't get to complain when people mention it. And then we finish the article by looking at legal jurisdictions and court hierarchies and so forth, and different areas of law, fields of law, like, you've got sort of, admiralty law and military law and all these things, and all of which are used as ways of kind of getting around certain things within the system of law, which are not necessarily friendly to the kind of behavior that the people in power have already decided that they want to engage in. So, they want to engage in criminal conduct within their own societies. They want to engage in criminal conduct internationally, and they want to get away with it. So I go into a bit of a social commentary here at the end, and that's, look, you can read it, and there are some kind of, points that I make in there, but mostly if you like a good rant and you want to have a bit of a, I've toned it down a lot in what I wrote, but I'll leave that for you to read if you want to see my choice thoughts. It's not just about Julian, and it's not just about the law, it's about how all of this stuff happens throughout history to a society, so that we end up in the situation where dickheads are in power persecuting the best of us. And for what reason? To support an agenda that is fucked up and stupid, and only a dumb cunt would ever be behind it. Where the fuck is the upside to this? There isn't one. It is a loss. I don't care how many people get richer. They are a small section of the community. Everything else is suffering. Our infrastructure is going down. Our services are going down. Everything is debilitated and damaged and corrupted. And we're putting out graduates from universities who haven't got a fucking clue. They don't even understand how to tell fact from fiction anymore because they're not being taught philosophical logic. Going into these specialist degrees, but they don't understand other areas of logic and reasoning and science, so they don't even know if what they're being taught is true or not. That just appears in the book, so it must be true. That's not a fucking argument. That's not a reason for believing anything. Anyway, I feel better. I got that off my chest. I hope this has been of some value to you, and for those of you who haven't yet had a look at it, please go to the websites linked, that there is an article published to locals and to Substack, and those articles have sort of general links about where I'm publishing things, plus links for the videos. And the reason I'd like you to go there and see that stuff in there, of course, are the links for supporting my work. What I want to do is I want to take some of this content and combine it to make a full show where I would come on and I would speak and I would introduce pre-recorded content, including some little comic bits. I would love to be working with some musicians, to have musicians to do music for the show, but to even sort of interview them, to interview other people. So to make a show of it and to have that as what I'm actually producing. So at the moment, all I'm doing is just producing bits of content which are being published. And when I've got enough there to produce my first episode, which would include, I hope, doing a live interview, having somebody that I can actually work with on air, that is my goal. And if you can contribute anything to the cause of what I'm trying to achieve here, then please do so. There's Buy Me a Coffee, there's Locals, there are direct links for Stripe and PayPal. Other ones like Patreon, I've got them set up, but I'm not using them just yet. So they're there. They're accounts that I've set up, but I really need sort of support to come through before I can start using more platforms, because I need more help to be able to get everything done, because doing everything on your own is too much of a workload. There's too much time taken to do everything, and so I wouldn't be able to produce content frequently enough if I was also taking on like all these additional platforms and having to learn them and moderate them. So yeah, so anything you can do to help, please do, and thank you very much for your time and attention. And to Julian, if anybody was to hopefully somebody who knows you can pass this on, let me just say, I grew up in the same state as you, okay? Firstly in Dimboola in Western Victoria, and then in Ballarat, and then moved to Melbourne and spent time all over the place. But I have a great deal of respect for what you've done. You are one of the most amazing people that I think our country has ever produced, one of the most amazing people that the world has ever produced. And I certainly hope that you can not only stay strong through everything, you know, that is going on, but I sincerely hope that the efforts made by everybody around you is going to rescue you and bring you out of this, you know. Stay strong, brother.